never been mutated in revenue records. We are not aware of it.
Yes.
And the persons who were the original owners,
Yes.
though party, Mr. Chapanari was appearing for them, it is ex-party.
Yes, that's all right. Then you don't have much of a quarrel in that because you are not concerned with this
But
application.
that was also ex-party. Lordship may have a look
One
at
second. What was the
it is an order challenging
yes.
order of the appellate tribunal under the Urban Civil and Regulation Act,
right?
where the order was passed holding in our favor. The state had challenged it. The matter was taken up on 21st. Some CA was taken up on 21st and directed that it should be placed, final hearing be placed on 24th. On 24th, nobody appeared and order.
Right, but then Mr. Thakur, please tell me your locus to question this.
I purchased this very
That is when
2023.
so this order is passed in 2011.
11.
Mr. Thakur, that is how very well. I am not that like. Please explain the concept of you are getting a locus ante the date when you have purchased the land. Yes,
I get
yes.
all the rights which the original owner gets.
No, not like that, Mr. Thakur. If there is an order, you say that this order was not mutated, this order comes against the original owner. So now, since I step into the shoe of
it is not mutated.
That's all right, Mr.
How do we know about it?
You are never a bona fide purchaser, Mr. Thakur. It is for your sellers to have informed you. Now, if
sellers were also not aware.
The 2011 matter, you are not aware.
No.
That's for the sellers to come and tell, Mr. Thakur. How do you file an affidavit on their behalf? What is your personal knowledge that your sellers were not aware? It is a matter of fact which comes by it's a personal knowledge. How would you vouch for that? How would you file an affidavit?
But if your lordship would see the judgment, well, that would become apparent.
That's all right, fine. I take it that was ex parte, but then it would be your sellers who would have to come and question it. You may not have a right after a decade saying that my sellers didn't know about it. How would you say this?
Because mutation entry is
that is all right, but that is for your seller. You may have been defrauded by your sellers, but that would not mean that you get any right because of that. You don't get any premium because of that. You are purchasing the property would not devolve you a better title than your owners had. Once the decision is taken by the High Court upholding the decision of the tribunal, matter is ended there.
Setting aside the decision.
Setting aside, fine. Whichever way you take it.
Setting aside the decision of the tribunal and there being nothing on record to show that the order is there, I buy the property.
Mr. Thakur, 2011, the issue had attained finality in 2011.
Yes.
Now, order of the High Court does not gain any for acceptability on basis the mutation.
I understand.
Right? So therefore,
it's only for revenue.
Right. So therefore,
your lordship may just
right. Yes.
I will try to find out if I can get the
what due diligence, Mr. Thakur, did you do?
Can I do of an order of the High Court?
No, not like that. Therefore, Mr. Thakur, then the issue would be that you may have been defrauded by your vendors. But then that would not give you a premium to say that the state should accept my sale. Yes.
Can I just say?
Yes.
If I want a title clearance, I will go to I won't get it.
Mr. Thakur, you are trying to say that an apparent can your sellers tell me something like this, Mr. Thakur, that after the decision, whether it was mutated, not mutated, whatever it is, after 2011 decision, did your vendors have any right to transact with the land? Did your vendors have any?
May not.
No, may not have. Do not have. Period.
So
if they do not have, merely because it was not mutated, can you claim that I become a bona fide purchaser? Only merely because of non-mutation, would you get a legal right? You can take action against your vendors. You can file a criminal complaint. You can ask whatever.
Can I say something?
Yes.
Let the vendors.
No. The vendors have not. Vendors now circuitously. Vendors cannot come here and say yes. Not at all. Yes. What is the state doing here? This kind of matter, state has filed any affidavit in reply?
No. It's nothing. It's
very well. It's a fresh matter. All right. State has taken instructions. Find out. Ask some senior law officer to appear. This is an apparent fraud on the state. How can you countenance such a thing? A matter which has attained finality in 2011, somebody has the cheek to come and say that no, because the order is not mutated, therefore I get a right to sell the property. Where are we? What are we looking at? Yes, yes, Mr. Thakur.
My lord, what I'm
Yes.
saying is that let me contact the seller.
No, no, sellers are already here. Sellers, Mr. Thakur, your sellers may say whatever.
If they are not aware of it, would they not be entitled to sell it?
How can you say that, Mr. Thakur? Can an order, if you, the just a fortnight back, the Honorable Supreme Court has come out with a decision that you cannot lay the blame at the doorstep of the advocate. You cannot say that I was not informed by the advocate, therefore I do not know anything. For 12 years, the matter stood as this. There was a final decision which was taken by the High Court. No? Yes.
Can I
Yes.
heard for 2 minutes?
Yes, please. Yes.
I am the seller.
Yes.
I'm not the buyer for the time being.
Right.
I'm talking as a seller.
Very well.
Now, I have not appeared. The matter is disposed of, your lordship.
Very well. I take it, Mr. Thakur. If you are appearing for the seller, please tell me.
I'm as if I am a seller.
Right, right. I assume that you are appearing for the seller.
No.
Right, and the seller. Seller, how can an argument from the seller be countenanced? The sir, for 12 years, I did not know about the matter being decided.
Look at the High Court record for a minute.
I assume that it was ex parte, Mr. Thakur. I assume.
I want your lordship to see the High Court record there. Now, if it is ex parte, if the High Court record, the state that the official record also shows that the matter has never been heard, the wakalatnamas are filed on days which are not feasible to file. The opponent's wakalatnama seems to have been filed before the petition is filed by the state. On the record. Now, just your lordship may hear. Now, if I am not at all,
Mr. Thakur, you as a respondent in this petition, you were.
I'm only talking directly as an owner, neither as a petitioner.
That's how I'm not. I'm not in the application for recall. I'm in the main matter. Special civil application was of the year 1999.
Yes.
Yes. You had already engaged a learned advocate. I want
the lordship to see that for a minute.
Show me which part. Yes.
Just show that.
Yes, please.
Just 1 minute.
Status page 586.
Just one. Status is
586.
Your lordship would see the status report page 586.
Yes.
586.
Yes. Yes.
Your lordship may see the special CA.
Yes.
Disposal date is shown as 24/3/2011. Now your lordship would see state of Gujarat for the respondents P.S. Chapaneri 127, J.K. Jaswant K. Shah for 127. These are the respondents.
Right. Yes.
Now your lordship would see the office details. Appearance note of the government leader 15/8/1999.
Right.
15, how can it be?
Yes. That would be a computerized. One second, Mr. Thakur. Is somebody coming and saying that, sir, I never engaged any learned advocate?
Your lordship, let me just finish it.
Yes, please.
15/8/99 appearance note of the government leader, 15/8/99 wakalatnama of Jaswant K. Shah, 15/8/99 wakalatnama of P.S. Chapaneri, 12/10/99 memo of the petition filed.
Right. So therefore, it is an apparent error. It's a glitch. It's a glitch.
Now,
yes,
further.
Mr. Thakur, that's what I'm asking you. What is, first of all, suppose if you are appearing for the seller, I take it that you're appearing for the seller. Yes.
I'm just saying that how would seller?
No. Mr. Thakur, you cannot ride on two horses.
No, I'm on a different.
I will not hear a subsequent purchaser saying all this, because these are issues which would be to the personal knowledge of those persons. You do not have any personal knowledge of all this. Can you make a statement, Mr. Thakur, that no, I did not engage learned advocate A, I did not engage learned advocate B? Would you be able to make a statement? No, apparently not, because, right? Now, this is a matter of 1999. Special civil application is of the year 1999. It is finally heard in the year 2011.
See that also.
No. So therefore, unless your vendor comes and makes a definite.
But I'm saying, your lordship, keep it after 2 days or 3 days.
No. Now we have taken it. Now we have come across this. Why should the vendor? It was for the vendor to have come here and said that, sir, I do not know anything about this. I have not appointed learned advocate A, nor I have appointed learned advocate B. I do not have anything here. Therefore, this order will not bind me.
I'm not saying it will not bind.
Right.
Your Lordship may hear me on
Yes,
this.
yes.
There's a vendor. This order is passed.
Right.
24/3/2011.
Right.
It would bind me in law.
Right.
But I'm not questioning
Exactly.
that issue.
Yes.
Now, how would a vendor, I'm on the fraud part,
Right.
how would a vendor whose petition is disposed of and he's not aware of it factually, which he will have to make a statement.
Right.
How would he be? And there is a subsequent petition filed where also the state has not said that this order has been passed. How would that petitioner, that vendor, be aware that he cannot sell the property?
Now, Mr. Thakur, so are we talking about an adverse right being created?
No,
This is the fact that the vendor did not know
I'm also seeking a review of this order.
No. One, you do not have any right. First, you do not have any locus to claim that since I have purchased the property in 23 or 24, I'll step into the shoes of the vendor. No, sir. These are issues of fact which could be only made.
Fact he can only say.
Only he can say.
Your Lordship.
And even because it was his petition, merely because after a decade you purchased the property which you did not. First of all, Mr. Thakur, for you to file this review application, you have to establish that the land was purchasable. If the vendor could not have, so therefore, if the vendor could not have sold this 2011, the matter ended. The land vested with the state. Irrespective of whether it was mutated, not mutated, that would be for the state to inquire, take appropriate action against their officers. Probably this is at the behest of those. This may be a cartel. One doesn't know. But no, you do not have any right here.
Your Lordship is prejudging the.
On the contrary, this is ingenuity. That only merely because it is not mutated, therefore it will not apply. How?
There are sale deeds which have been done between 1999 and 2011.
Maybe nothing after 2011, nothing existed for the seller to have transacted. And if he had done something during the pendency of this petition, probably it is the lethargy of the state not to have taken appropriate action or brought this to the notice of the court in 2011. That, sir, look here, this is the respondent.
Which is cropping up is that if the order of the division of the single judge of the Gujarat High Court, I can demonstrate is erroneous. Without bringing all facts on record, somebody will have to check.
No, that is fine, sir. But then that could have been done within reasonable time. One, and that could only be said by the vendor, not by the subsequent purchaser.
Saying your Lordship may give me 3-4 days.
No, sir. How can this go? This application has to go. No. Yes, you cannot. You do not have any locus, sir.
Your Lordship may just keep it for 2 days. Let me find out what.
Very well. All right. Call some senior law officer. Get the entire records for me. Find out how this has happened. Put the entire revenue department on task here. This is a fraud, pure and simple. Such a fraud cannot be permitted to be perpetrated. Just merely because an order is not reflected, take action, throw your officers out. If somebody is in connivance, make sure that he doesn't remain in service for a day. I would not want to hear any submission like this, that because an order is not mutated in the revenue record, the order has no efficacy. No, sir. Yes.
One of the handwritten order of 1999, where the question for the reviewed. It is not the case that once now.
Sir, I am looking at an order of 2011 of the High Court which is set aside. Now, that merely because that order. And 1 second, what are your officers doing? Take action against the entire machinery. If an order of the High Court in your petition is not mutated, that means that is something very seriously wrong with the system. Yes, and then somebody has the gall to come here and say that no, sir, because the order is not mutated, I do not know about that order and therefore I purchased it. No, I will not hear such a thing, and I will not hear the state. If any of your officers are acting in connivance, they should go home. Yes, absolutely. They should not even receive their pension. The entire machinery should go home. This is absolutely a fraud, out and out. And I want to make sure that your senior most officers of the state, starting from your revenue secretary, know about this and make sure that the annoyance of the court of permitting such things happens are brought to the notice.
Fine.
Yes, make this is something, this could not have been done without your officer's connivance. Yes, this could not have been done.
Correct.
Yes,
Because
and when I'll keep it on Wednesday, make sure that some senior officer, a law officer, as well as some senior officer of the state is here.
Correct.
Yes, the message should go that such frauds will not be, High Court will not be a party to such a fraud.
Fine.
Yes, make sure that somebody senior, quite senior is here.
Fine.
Yes, yes, Mr. Thakur.
the
Yes.
lordships feeling that there is a fraud.
Mr. Thakur, yes,
We
yes,
heard it.
yes.
Or as far as fraud is concerned,
Mhm.
if the original owner, let me put it, if
Yes.
the original owner is not intimated about the rejection and his order is in his favor of the appellate tribunal, in that event,
Mr. Thakur, is that argument open?
no,
Once you
I'm saying,
therefore,
should there be a fraud then?
yes, Mr. Thakur, that please appreciate that you knew as the original.
How do I
No, the original owner had engaged learned advocates in the High Court,
Yes.
right? The original owner knew that there was a matter pending in the High Court. Are you trying to say that from 1999,
It did not come up on the body.
Sir, please allow. After 1999, when the writ petition was filed, and till 2024, the original owner slept over it, thinking that the matter is pending in the High Court.
Look at the record.
No, sir, no.
It has not come up even once.
That is okay, but then what were your learned advocates doing? And what? I would not go into the learned advocate part. Only a fortnight back, the Supreme Court has very clearly said that it will not be open for a party to lay the blame at the doorsteps of the advocate. If a party engages an advocate, it is for the party to follow up with the advocate. You just say that I've engaged an advocate, I forgot it. No, sir. Equally, it was the original owner's duty to have followed it up. That what is the status of the case? And after a decade, did you know that, Mr. Thakur, as a seller, you knew that the matter was pending?
No.
You,
Seller would.
a seller would know, right?
That's good, no, because
Right?
I get-
No, sir.
Who would know if he has engaged a-
Right. So, if the seller knew about this matter, how on the earth could you have sold this the matter?
Because there is no order.
Right. So, there may not be an order, but when you are transacting a land, when you are transacting with regard to a particular property, which is subject matter of a writ petition, which has remained pending for so long, would you not even go and ask your advocate that, sir, what is the status before selling it? Before selling the land, કે સાહેબ મારી આગળ પિટિશન શું થયું? મારે જમીન કાઢવી છે. એટલું તો reasonable માણસ, we go absolutely on basis what a reasonable person would do. Would not a reasonable person go to his advocate and say that, sir, મારે રૂપિયાની જરૂર છે, મારે દીકરીના લગ્ન છે, whatsoever, મારે જમીન વેચવી છે, આપણી મેટરમાં શું પરિસ્થિતિ છે? Either he will say that, સાહેબ વહેલા નિકાલ થાય એવું કઈ છે, અથવા he will ask something else. What did your vendor do? So you may have been defrauded by your vendor, but that will not mean that no, you get a title better than what your vendor
I'm
had.
saying that.
Yes.
I'm saying that if in 1999 the order is in my favor, writ petition is filed in the High Court. In that writ petition, I have engaged a lawyer.
Therefore,
To this
fine, sir.
extent, factually,
Right. Now we'll take it up on 11th. We'll take it up on 11th. Make sure that on 11th I have the complete instructions, Mr. Kanara, with a senior law officer, a senior officer here, and a senior officer of the state.
Right.
Yes. So Wednesday, Mr. Thakur. Yes,
Yes.
please. All three matters put together. 1, 2, and 16. Least to
Because in the interregnum, there was also one judgment in the revenue proceedings of the Gujarat High Court.
Sir, I'm not,
There was nothing
Mr. Thakur, I'm not finding fault with you. One, you may have been